citizens and the governments. Right to information. The Right to Information Act 2005 was passed by the central government. The act was passed as a result of people's mobilization as well as in recognition of the provisions in the Constitution that provides right to citizens. In this chapter, we briefly look at the two roles that need to be played for getting the benefits of RTI to the people. The first one is the role of the government departments and the second is that of the citizens. What is information? Every government department functions on the basis of certain rules and regulations. There are rules and regulations that say how health department should select, appoint, transfer doctors and nurses in the hospital, or how medicines should be procured and distributed. It could be in different forms as described in the RTI as following: material in any form including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form and information relating to any private body which can be assessed by the public authority under any other law for the time being in force. What is it that a citizen can do with this informal is crucial. Suppose there is a suspicion about malpractices in the functioning of the department. Individuals can collect the information and challenge the procedure followed. Enactment of the RTI effectively means that individual government departments now have the responsibility to maintain records and make them available to any citizen who may ask for it. Moreover, it is possible that even before being asked by citizen, a department may voluntarily disclose its process to public. Who is responsible? There are public information officers (PIO) in every department as well as an appellate authority in the same department. All PIOs of all departments and the appellate authority are answerable to the State Public Information Office, with the State Public Information Commissioner (SPIC). If the government department falls under the central government, then the PIOs are accountable to Central Information Office (CIO) with the Central Public Information Commissioner (CPIC). These departments are autonomous like the Chief Elections Commission or Judiciary, etc. It is important to remember that information officers are, however, not responsible to take action if there is violation of laws in the functioning of these departments. This power would still remain with the courts of the country, with the SPIC or CPIC can, however, do is to ensure the correct information is provided within the specified time. In case some PIOs refuse to give information, such officers can be penalized in the orders of the SPIC or CPIC. The Act identifies public authorities who are expected to follow the RTI Act as following: an institution created under the Constitution, made under the laws of Parliament or state legislature, created through the notification of or order of the appropriate government. It may include anybody owned, controlled, or substantially financed, nor non-governmental organizations substantially funded by the governments either directly or indirectly through the funds. Exemptions for disclosure. The law permits the governments not to disclose certain information. Some of these include such as information that could affect the sovereignty and integrity of India, matters that could be of strategic, economic and scientific interest of the state in the context of a foreign powers, information that could breach the privilege of parliament or state legislature, information received in confidence from foreign government, information that could endanger the life or physical safety of a person, cabinet papers or records of council of ministers and secretaries. This means that most of our armed forces and security agents are outside the purview of information commissions. People and RTI. Any citizen today can approach any department of the government and ask for any information that could be in the form of a record. It is not necessary that he or she gives an explanation as to why the information is required. This request can be sent through a handwritten letter or electronic mail. Suppose an individual is not able to write the application, he or she can also access the information by orally dictating it to at the SPIO with PIOs individually. Who is collecting the information can remain anonymous but will have to provide a postal address so that the records could be sent to him or her. Democracy requires an information citizenry and transparency of information. This can help to contain corruption and hold governments accountable to individual citizens also. Legal Service Authority. Under the Legal Service Authority Amendment Act 2002, legal services authorities are constituted to provide free and legal services to the weaker sections of the society. This is to ensure that opportunity for securing justice are not denied to any citizen by reason of economic and other disabilities, and to organize Lok Adalats to ensure that the operation of the legal system promotes justice on equal opportunity basis. Now the Lok Adalats are consulted in every state under the Legal Service Authority Act 1987. People are now using Lok Adalat mechanism for expeditions and inexpensive justice. It is an opportunity to settle long pending court cases through Lok Adalat in short time and without any expenses. Objects of Legal Service Authority. The LSA Act was enacted to constitute Legal Services Authority for providing free and competent legal services to the weaker sections of the society, to ensure that opportunities for securing justice were not denied to any citizen by reason of economic and other disabilities, to organize Lok Adalats to ensure that the operation of the legal system promoted justice on the basis of equal opportunity, to develop an effective alternative innovative dispute resolution mechanism outside the courts. Organization of legal services. A nationwide network has been envisaged under the Act for providing legal aid and assistance. National Legal Services Authority (NALSA) is the apex body constituted to lay down the policies and principles for making legal services available under the provisions of the Act and to frame most effective and economical schemes for legal services. It also disperses funds and grants to state legal services authorities and NGOs for implementing legal aid schemes and programs. In every state, Legal Service Authority is constituted to give effect to the policies and directions of the Central Authority NALSA, and to give legal services to the people and conduct local adalats in the state. State Legal Services Authority is headed by the Chief Justice of the State High Court, who is its Pardon-in-Chief. District Legal Services Authority is constituted in every district to implement legal aid programs and schemes in the district. The district judge of the district is its ex officio chairman. Taluk Legal Services Committees are also constituted for each of the taluk or mandal or of a group taluk or mandals. A senior civil judge operating within the jurisdiction of the committee, who is ex officio chairperson. Functions of the Legal Service Authority. The Legal Service Authority shall perform following functions at various levels: give legal services to persons who satisfy the criteria laid down under this Act, conduct Lok Adalats, undertake preventive and strategic legal aid programs, perform such other functions as Legal Services Authority fixes by regulations. What legal aid facilities are available under the Legal Service Authority? The LSA, through Lok Adalats, settles long pending court cases in short time without any expenses. In cases pending before courts, both the parties or one of the party has to make an application to the court for the referring of the case to Lok Adalat for settlement. If the court is prima facie satisfied that there are chances of such settlement, then those cases will be referred to Lok Adalats by the concerned courts. Who are entitled to get benefit under the Legal Service Authority? The following are the persons entitled to get free legal support: a member of scheduled caste or scheduled type, a victim of trafficking of human beings or beggars, women and children, a mentally ill or otherwise disabled person who are victims of mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake, industrial disaster, industrial workers, persons in custody, including custody in a protective home within the meaning of Clause G, Section 2 of the Immoral Traffic Prevention Act 1956, or a juvenile home within the meaning of Clause of Section 2 of Nursing Home within the meaning of Clause G of Section 2 in the Mental Health Act 1987. 87. Persons with the annual income of not more than rupees 1 lakh. Whom to approach and how? Persons can approach for justice at various levels as given hereunder. At district level, Secretary, District Legal Service Authority, District Court Complex. At state level, Member Secretary, State Legal Service Authority, Nyaya Seva Sadhan, City Civil Court Buildings, Purna Haveli, Hyderabad, 5 lakh 2. Or people who need legal assistance in the case field in the High Court shall apply to the Secretary, High Court Legal Services Committee, High Court Buildings, Hyderabad, 5 lakh 66. Entertainment of disputes and benefits of Lok Adalat. There is no court fee, and if court fee is already paid, the amount will be refunded if the dispute is settled at Lok Adalat according to the rules. The basic features of Lok Adalat are the procedural flexibility and speedy trial of the disputes. There is no strict application of procedural laws like Civil Procedure Code and Evidence Act while assessing the claim by Lok Adalat. The parties to the dispute can directly interact with the judge through their counsel, which is not possible in regular courts of law. The award of the Lok Adalat is binding on the parties, and has the status of a decree of civil court, and it is non-appreciable, which does not cause to the delay in the settlement of disputes finally. Provide a free legal advice from the advocates appointing advocates to argue the cases in the courts, bear the court expenses pertaining to the case of the person entitled for free legal services, and support providing photocopies of the judgments on free of cost.
మా వీడియో కనుక మీకు నచ్చినట్లయితే లైక్ చేయండి, షేర్ చేయండి. ఇలాంటి మరిన్ని వీడియోస్ కోసం మా ఛానల్ని సబ్స్క్రైబ్ చేసుకోవడం మాత్రం మర్చిపోకండి. థ్యాంక్ యూ ఫర్ వాచింగ్.